Good evening. Last one for a while. So we're going to cover three huge topics tonight, which are costs, appeals, and a very special power that only exists in the magistrate's court, which is the power of review. I set out for you here a couple of key practice directions for you to have a look at and provisions in the prosecution code. I'll leave you to look through those yourself. Let's get started on costs. Now, whenever we're thinking about the subject of costs, we need to remember that there's always two sides to costs. There's the costs that the prosecution incur in the proceedings, and then there's the defense costs, the costs that the defendant himself spends on his representation, etc. So always remember, when it comes to costs orders or refusals, to think about who's going to pay the defendant's costs, who's going to pay the prosecution's costs. But some general principles: there is no inherent common law power of the court to make a costs order or to refuse costs. There has to be a statutory provision giving the court the power to make a costs order or to refuse costs. And costs is a discretionary power. The ordinance that you need to take a look at is the Costs in Criminal Cases Ordinance. However, it doesn't apply to the CFA. The CFA ordinance has its own provisions on costs. But as general principles, any cost orders should be compensatory, not punitive in nature. The exception to that is Section 18 of the Costs in Criminal Cases Ordinance, which relates to wasted costs order that can be imposed against legal representatives. Costs, therefore, the idea is to put the party back in the same position before the litigation commenced. And the cost should cover expenses properly incurred. So you may have a procedure in which costs are taxed. That's very common. In other words, the taxing master looks at the parties' amounts that they say they've spent and then decides whether they're justified or not. And any costs imposed should be just and reasonable. But if you are convicted, as a general principle, you're liable for costs. If you are acquitted, you generally get your costs. So if we look at this from the two sides of the cost coin, if a defendant is convicted, that means not only does he have to pay his own costs, but he can be ordered to pay the prosecution costs. If he's acquitted, then generally the prosecution will be ordered to pay the defendant's costs. But in certain circumstances, an acquitted defendant may be refused costs. So that would mean that he has to pay his own costs. Doesn't mean he has to pay the prosecution costs. It just means that he has to pay his own costs. So we'll look at what those circumstances are. But in criminal cases, costs do not follow the event. So next few slides deal with some situations where the prosecution may be ordered to pay the defendant's costs. So some provisions under the magistrate's court as well as in the district court. For example, if the prosecution decide to withdraw the information or complaint, or the defendant is, say, acquitted after a no case to answer submission, then costs may be awarded to the defendant. And similarly, some provisions as well in the court of first instance. You'll see here, remember that if the defendant is committed to the CFI via the paper committal route, without a preliminary inquiry, then he has the right to apply for a discharge when he gets to the CFI under Section 16. And that would operate as an acquittal. So he would usually be awarded costs in that situation. Now, it's important for us to understand when an acquitted defendant may not get his costs. General principle, he gets his costs. But if the defendant is acquitted, but he's only acquitted on a technicality, or because he has brought suspicion upon himself and or led the prosecution or police to think that the case against him was stronger than it was, in other words, he may not have told the truth, then he may be deprived of his costs. So leading cases are this Court of Final Appeal decision in Tong Koon Lin. The court will look at his conduct generally, and it can even include his conduct throughout the investigation, not just his conduct at trial. But a defendant who just exercises his right of silence should not be penalized with a costs order against him. Examples of when a defendant who's acquitted may not get his costs, for example, if he's made inconsistent statements to the police, right, then he would have brought suspicion upon himself. Some other examples of bringing suspicion upon himself is, I put a recent case for you, Hong Kyu Yu. And the court can look at his suspicious behavior at the time of the alleged offense in question. Also, Wong Shuk Chun. This is where the defendant appeared to have claimed a government housing allowance that she wasn't entitled to because her husband was already getting a private housing allowance. And she'd even written a letter stating that his employer was not prepared to claim, to issue a letter from the employer to say that he wasn't receiving an allowance. And that wasn't actually true. So she brought suspicion upon herself by making inconsistent statements. And the court can also look, according to the Wesley Xiao case, at his conduct even before the investigation. So his background before charge, provided that it's not inconsistent with the presumption of innocence or his acquittal. Now, in that case, the issue for the prosecution was they were lacking one of the elements of the offense. And there was a possible summary offense, but the limitation period had expired. The magistrate, though, seemed to have formed the view that the defendant had committed the summary offense. But ultimately, of course, the defendant was acquitted because the prosecution couldn't meet their burden of proof. And the magistrate used her own view to deprive the acquitted defendant of costs. The CFI judge on appeal said that was inappropriate. It was not the defendant's fault that the prosecution could not establish the element of the case, and so the defendant shouldn't be punished with costs being refused following his acquittal. Now, in what circumstances? So far we've been talking about when a defendant is acquitted and he doesn't get his costs. But in what situation may a defendant have to pay not only his own costs, but the costs of the prosecution? If he's convicted, he may be ordered to pay costs on conviction. But again, costs don't follow the event because the prosecution have the burden of proof because of the presumption of innocence. So if all that the defense do is put the prosecution to strict proof by testing the prosecution case, then that wouldn't be enough to make a convicted defendant have to pay the prosecution costs. The court wants to look at whether there are special circumstances which put the prosecution to extra expense. So some examples of special circumstances may be where the prosecution have asked the defense to agree to admit a Section 65B statement or to admit certain facts under 65C, and the defense have refused. They've forced the prosecution to call that evidence at trial. So essentially they have prolonged the trial. And then at trial, the defense haven't challenged these witness statements. They haven't asked the witnesses any questions under cross-examination, or they have not disputed the facts that they were asked to admit. So in that circumstance, the convicted defendant may be ordered to pay the prosecution costs. Another example of putting the prosecution to extra expense is taking every single point on cross-examination that could possibly be made, even if it's irrelevant. So again, you're forcing the extension of the trial. Other examples of special circumstances, if the defendant has not complied with the procedural rules, like failing to give notice of an alibi. Remember, he has to give that notice not less than 10 days before the commencement of the trial. If he doesn't do that and then seeks to introduce the alibi evidence, the judge may allow it, but there would inevitably be an adjournment and then cost consequences for the defendant. On appeal, the test really is whether the defendant's appeal is without merit. In other words, not reasonably arguable. If the defendant appeals his conviction, but his appeal is without merit, then costs may be awarded to the prosecution of that appeal. And we're still applying the same principles for considering the situation of costs on appeal, just like we are for the original trial, right? They are compensatory, not punitive, and they have to be just and reasonable. How much could the defendant be ordered to pay? In the MC, the maximum is $30,000. There isn't any limit in district court and CFI or CA proceedings, but it's really important that the court consider the financial means of the defendant. That's the case of Y. Sao Chen. So costs should never be imposed against a defendant who doesn't have the means to afford the cost order, right? So you have to take instructions from your client on his financial situation in order to be able to resist an application from the prosecution for costs. If the defendant is represented by the legal aid department or the duty lawyer service, then if he's acquitted, he's actually only entitled to get costs up to the amount that he has personally incurred. And that would be in the duty lawyer service example, the small amount, the handling charge of $630, I think it is, that he pays for the duty lawyer service to represent him for the duration of the trial. The duty lawyer service cannot get back the costs that they have spent in the defense. The defendant can only get back that handling charge. Section 17 of the Costs in Criminal Cases Ordinance is important because this is the power of the court to impose a cost order where it feels that costs have been unnecessarily or improperly incurred. And there's no need for any grave impropriety to be proved. And an example of this case is the case of Ao Yang Lai Hung, in which the prosecution had applied for an adjournment to amend the charge. The prosecution had applied to amend the charge. The defense then asked for an adjournment, and the reason was that they wanted to investigate new evidence. And then when the case came back to court, they didn't actually produce any new evidence. And then on the cost application, they argued that they needed time to research the amended charge. The Court of Appeal, though, said that the trial judge had taken wrong factors into account. And here, the prosecution were able to justify why they wanted to amend the charge, and the defense had failed to show a causal link between the amendment of the indictment and the need to adjourn. So in that situation, the cost order that had been imposed in the lower court was set aside. So if you are applying for costs against the other party under the Section 17 provision, you are basically arguing that they've done something unnecessary or improper. And as a result of that, you have incurred costs. So the burden of proof is on you because you're the one making the application for them to pay these unnecessary costs. But there has to be a causal link between the costs that you say you've incurred and their improper or unnecessary action. Wasted costs under Section 18 of the CCCO is the power that the court has to punish, to make a punitive award of costs. So this is a situation in which, unlike the other provisions of the CCCO, the cost order is not compensatory. This is a punitive award of costs, and it's imposed on a legal or other representative for wasted costs. We don't get too much guidance from the definition of what wasted costs are, just seriously improper acts or omissions, undue delay, or other serious misconduct, which in light of what they've done, it is unreasonable to expect the other party to pay. So the power to sanction a legal representative. Now, if you ever want some light relief late at night, maybe this case of Rees Sutherland is the case to read. Now, this was a cost order that was made against defense counsel in the amount of $180,000. This was a huge order for costs for this counsel to bear personally. Why I say you should read the case for some light relief really is it's quite rare to see a court on appeal use such strong language and be so critical of a professional lawyer. What happened in this case is that it was originally set down for a 3-day trial. And it was a 3-day trial about indecent assault. The allegations were that the victim had been sitting in a movie theater, it's quite empty, and the defendant had come in and chosen the seat next to her. And as the movie went on, at one stage, she sort of felt something brush against her leg. She thought, well, a bit strange, but she ignored it, just thinking probably accidentally. And then a short time later, she felt what seemed to be a deliberate stroking of her thigh. So at that point, she jumped up, called for help. The manager came in, and the defendant ended up getting charged with indecent assault. At trial, unfortunately, he was represented by this defense counsel. And what was originally set down for a quite straightforward 3-day trial ended up being more than 40 days. And a large part of that was because of the protracted, lengthy cross-examination that the defense counsel subjected the prosecution witness to. He basically asked questions in cross-examination. And before I tell you what he asked, I should remind you that questions in cross-examination, I said before, cross-examination is not a fishing expedition, right? You shouldn't be wasting time by asking a whole load of irrelevant questions. Questions in cross-examination should be directed to your case theory. So this counsel in cross-examination asked a lot of questions about whether the victim liked to watch movies, what kind of movies she generally watched. He asked her specific questions about the particular movie that had been playing at the time of this indecent assault. I think what he was trying to do was to allege that, or he did put this to the witness at one point, that she hadn't really been paying attention to the movie, she'd fallen asleep. That's why he's asking questions about the content of the movie. But whether she generally likes to watch movies is not relevant at all. He actually also asked the court to play parts of the movie. In fact, at one point, he tried to suggest that the entire movie should be played before the court, and the court quite sensibly said, no chance. And he then proceeded to ask this victim whether she regularly flew economy class on Cathay Pacific, because his theory was that the seats inside the movie theater were very similar to those on an airline. Again, I struggle to see why this is relevant in the slightest. And he also asked her about what movements she made while she was asleep. He was putting to the witness that she fell asleep, or that his client had fallen asleep. And so he'd made these kind of unconscious movements, I think, while he was sleeping. But again, if you're asleep, then how do you ever know what movements you make? So a lot of his cross-examination was completely pointless and irrelevant. And the Court of Appeal described his conduct as obtuse, pointless, irrelevant, ludicrous, badgering, bullying, obdurate, relentless, remorseless, indiscriminate, repetitious, prolix, and displaying neither skill, restraint, nor sensitivity. In short, an egregious example of how cross-examination should not be conducted. So that's why I say that it's worth taking a look at, because it is very rare for the court to be so critical of defense counsel. And in fact, in this case, the counsel was referred to the barrister's disciplinary tribunal for them to look into his conduct. So a wasted cost order is not just is compensatory as well as punitive. And you don't need to show dishonesty, but just a mere mistake or error of judgment or a wrong tactical decision is not enough. You've really got to show conduct which goes beyond the level of professionalism that is expected from the lawyer in the case. And then also the case of Kelvin Y.C. Leung. This is another interesting case to look at. This was a very simple traffic-related offense. What had happened in this case was that I think a domestic helper had dropped off the child or something she was looking after at the American Club, and she was crossing the road late at night, and she was hit by a taxi. And so this trial, though, wasn't about the prosecution of the taxi driver. Unusually, she was prosecuted for, I can't remember exactly what the offense was called, but it's basically crossing the road in an unsafe location. She'd crossed on the bend of a road. So she's prosecuted for a very minor offense, but she'd sustained quite serious personal injuries. So in situations like that, the police don't usually prosecute the victim of the car accident. I suspect the reason they did here was because she was a domestic helper. But what happened at the trial was her defense counsel, this trial was originally supposed to be 2 days and ended up lasting 91 days over the course of a couple of years. And her defense counsel tried to justify a lot of his questioning by saying that whether she was convicted of this offense, it was essential basically to her personal injuries claim for her to be acquitted. So he was using that to justify why he had to ask the questions that he did. But actually, why this case is also a good one to read is because there was clearly a bad relationship between the magistrate and the defense counsel and the defense solicitor. So the court refers to constant bickering. And the court on appeal is very critical also of the magistrate, because the court says, well, the magistrate didn't behave professionally either. And in allowing this trial to drag on for so long, when this is just a very minor offense, the magistrate had not used judicial resources correctly. So you can see here, they talk about it meandering sluggishly to its eventual conclusion. They refer to scandalous exchanges that the deputy magistrate had with defense counsel and solicitors, fueled by mutual disrespect and animosity. And they say in the strongest possible way that the deputy magistrate failed in her duty to manage the trial. At one point, defense counsel said to the magistrate, "Are you insane?" And the court took particular offense to that, because obviously it's not just a personal insult, it's an insult that's made in open court against a judicial officer. So based on that, even though the defense counsel immediately retracted it, he actually didn't apologize, and they ended up recommending that he be referred to the barrister's disciplinary tribunal. As the trial went on, the relationship between the deputy magistrate and defense counsel became so bad that the defense counsel actually withdrew from representing his client and the defense solicitor took over. But the bad relationship continued. And so the deputy magistrate at one point referred to the solicitor as a good boy, like very patronizingly. after he'd said, what a great team your worship and the prosecution appear to be. So there was all kinds of like insults and arguments flying back and forward. There was various applications for judicial review, many applications for adjournment. The whole thing was just a mess. But the Court of Appeal, their opinion was that because everybody was at fault, so originally the magistrate had made a wasted costs order against the defense counsel and the defense team. On appeal, the Court of Appeal were also critical of the deputy magistrate and to a lesser extent critical of the prosecution as well, because they felt the prosecutor had also helped to fuel some of this argument. So they actually ended up setting aside this wasted cost order because really everybody had their part to blame, even though it's quite clear that they think that defense counsel bore the brunt of that responsibility. Yes, do you have a question? You had a question? Oh, I thought I saw you raise your hand. Okay. All right. So let's talk about what if you apply for costs and those costs are refused. Under Section 19 of the Costs in Criminal Cases Ordinance, you can appeal an award of costs, but not appeal a refusal to give you costs. So if the defendant is acquitted and he applies for costs and the court refuses his application, then he cannot appeal under Section 19. He would need to use the judicial review avenue unless there's another statutory provision which gives him that power. So if he's in the magistrate's court, Section 113 covers it. He can appeal against a refusal to give him costs. Similarly, if he's in the CFI or CA, he can rely on the final appeal ordinance. However, this is a quirk of the legislation. If the defendant is acquitted in the district court and costs are refused, he cannot appeal that refusal to give him costs. Why? Because there is no provision in the district court ordinance that allows him to appeal against the cost refusal. His only option is judicial review, and there's a high threshold to be successful on judicial review. If costs are awarded, then Section 19 applies. But always remember that costs involve the exercise of discretion, and therefore, on that basis, it can be hard to overturn a cost order on appeal. But if you do appeal, you appeal by notice of motion, and you have to appeal within 21 days of the cost order. You always need to take instructions from your client so that immediately upon the conclusion of the case, you can be prepared to make your costs arguments. So those are the slides on costs. Don't ignore it just because there's only 22 slides, right? Costs are very important. And if you look at some past exam papers, you'll see that there are questions on costs. Any questions about costs before I move on? Okay, let's get to appeal then. There has to be a statutory basis to appeal or to apply for a review. It isn't a right that exists at common law. We do know from Article 11 of the Bill of Rights that the defendant has a right to appeal his conviction and sentence. But we have to look to a statutory provision in order to give us that right to appeal. When we're appealing, we're going up the chain to a higher court. When the defendant reviews, he's staying within the same level of the magistrate's court. He's not going to a higher court. So in the exam, look carefully at the wording of the question. Is it asking you about appeal, or is it asking you about a review, right? So if the question is asking about a Section 104 review, don't waste your time answering questions about the power to appeal a magistrate's decision, because that's not what the question's asking you. And in my experience, a lot of Hong Kong youth-based students in the criminal procedure exam don't either read the question properly or haven't done enough preparation going into the exam. And so all that they do in the exam is basically copy and paste out chunks of lecture slides or materials. And they totally waste their time because they're not answering the question asked, right? Remember, in the exam, you have to answer the question that you have, not the one you hoped you'd get, but you didn't. You must answer the actual question. So you need to read it carefully, right? So I always think like highlighter, different colored pens are useful. So you can highlight the key words to focus your mind. And I always jot down little notes on the side of the question as well, so that as I'm reading it through, so when I go back to answer it, I know, I remind myself, right? And you should, as you work your way through the questions, you should keep referring back to the question and thinking, am I actually answering this question, or have I gone off on a wild goose chase down the wrong path, right? So think carefully about what the question is. An appeal is not a retrial. It's not a second trial. The same witnesses do not come back and testify before the higher court. So the appeal court is looking at what happened below and deciding whether there are good grounds for an appeal. So if the magistrate has reached a decision, there are two possibilities to appeal, and the appeal is to the CFI because that's the higher court. You can appeal by way of case stated under Section 105, or you can appeal against conviction or sentence under 113. But in the magistrate's court, there's this third special provision under which a defendant can, or prosecution can, seek a review of the magistrate's decision. You don't need leave to appeal or review a magistrate's decision, but you may need leave to appeal from the district court or the CFI to the Court of Appeal, depending on what your grounds of appeal are. So I just put a little summary chart here for you on slide 24, just to show you the options of the prosecution and the defense to appeal or review a magistrate's decision. So either the prosecution or defense can use the 104 review procedure. Either the prosecution or defense can use appeal by way of case stated. But under Section 113, the prosecution can only appeal against an order or determination of the magistrate that is not relating to or in connection with the offense. Okay, well, I'll explain what that means later. But the defendant can generally appeal his conviction or sentence to the CFI under 113. And the prosecution also has this power of review of sentence under 81A. So we're appealing up to a single judge in the CFI. And if you are appealing, you have to choose before you start whether you're going to appeal by way of case stated, whether you're going to appeal under 113. You can't appeal under both limbs at the same time. It's an either or situation. If the judge in the CFI hears a magistracy appeal and a second appeal is sought, then the appeal is directly to the CFA. You don't get the right to appeal to the Court of Appeal from a magistracy appeal heard in the CFI. The reason for that is it would give an appellant an extra appeal, an extra level of appeal compared to appellants in the district court or CFI, right? Because if the case originated in the magistrate's court and there's an appeal to the CFI, that's appeal 1. If another appeal was then allowed to the Court of Appeal, that would be appeal 2. And then there could be a third appeal to the CFA. So that would be 3 appeals up the chain. But if the case originates in the district court or CFI, first appeal to the Court of Appeal, second appeal to the CFA, right? So that's the reason why from a magistracy appeal in the CFI, the only option is to go directly to the CFA. But it has to involve a point of substantial and grave injustice, which is a very high threshold to meet. Appeals by way of case stated are very limited in scope. The appeal can only relate to a question of law. So essentially, you're arguing the magistrate has made an error of law or acted outside of his jurisdiction. But the prosecution or defendant can use it. If the prosecution wants to appeal against sentence, it can use Section 105. But you can't use it to appeal findings of fact. It has to be a question of law. And you can see from the procedure here that it involves drafting up a case, going through the findings of fact and the submissions, what the decision was and what questions you want to raise on appeal. The magistrate has to state and sign a case, and the applicant gets a statement of findings. He has to prepare a case. So in practice, defendants never use Section 105 to appeal. It is more costly. It takes more time. It's more fun. It's very cumbersome, very annoying and difficult because there's all these procedural hoops that you have to jump through. So defense rarely use Section 105 of the magistrate's ordinance to appeal. If they do, it's probably because they got it wrong. Right, so just think of Section 105 as this theoretical route of appeal for a defendant, but one which in practice is not one that would be ideal for them to use. But the prosecution, on the other hand, will largely need to rely on it. You have to appeal within 14 clear days of the magistrate's decision. And clear days means you don't count the day of the decision. You start counting the 14 days on the next day. And an extension of time of that 14 days is not possible. Section 113 refers to the alternative procedure of bringing appeals, which makes it seem as if this is like the less desirable way, right? And also the fact that it comes after Section 105 chronologically in the ordinance. But actually this should be called the better appeal method, right? Or the preferred method. It's only available to a defendant under Section 113, subsection 1, because a defendant is a person who's aggrieved by the conviction, who did not plead guilty or admit the truth of the information or complaint. So subsection 1 does not apply to the prosecution because they have not pled not guilty. And it doesn't apply to a defendant who pleaded guilty. So a defendant who pleads guilty in the magistrate's court cannot appeal under Section 113 MO, right? Because that bit in bracket. What it means is that he has to seek to reverse or withdraw his guilty plea, right? By arguing that there was some kind of fundamental mistake of law or duress or something. But under subsection 2, he can appeal his sentence whether he pleaded guilty or not guilty, unless, of course, the sentence is fixed by law. So you couldn't use Section 113, subsection 2 to appeal your fixed penalty of $320 for parking, right? Because that sentence is fixed by law. The prosecution, though, can appeal under subsection 3 of 113 against an order or determination of the magistrate, provided that order or determination is not relating to or in connection with an offense. So what does that mean? They can use subsection 3 to appeal like a costs order of a magistrate, for example, because that's not a determination relating to an offense, right? It's a separate cost order, or maybe some other decision that the magistrate has made. They could use Section 113, subsection 3, but they can't use it to appeal the defendant's acquittal. They can't use it to appeal against the fact that an O&E bindover has been used, for example. They'd have to rely on Section 105 and appeal by way of case stated. But remember that only is possible if it's an appeal on a point of law, not on a question of fact. So how do you appeal under 113? The language is different. Section 105 refers to you have to appeal within 14 clear days. But Section 113 has no reference to clear days. It just refers to 14 days. So in practice, that's taken to mean that for an appeal under Section 113, you count the day of the order or decision. Like, so that you count the day of conviction as day one, or the day of sentence as day one. And then the 14 days starts from day one of the conviction or sentence, right? For Section 105, because there's clear days, you start counting on the next day, right? So this is relevant to the deadline to appeal. But you can see for both of them, it's 14 days. So time is tight. Section 113, different for 105, you can get an extension of time to make your appeal if you can show good cause. But you have to fill in the form, either 101 if you're appealing conviction or 102 if you're appealing sentence. So you fill in this form in writing and it's signed. And then the statement of findings is prepared by the magistrate with the reasons for verdict. So because time's so short in practice, in the Form 101, you file what's called initial grounds of appeal. It's sort of like a placeholder. And then later, when you have the transcript, you have the written reasons for verdict, you perfect those grounds. Because in that tight 14-day period, you may not have fully formulated all of the grounds of appeal. But you don't need leave to appeal under 113. So remember, to appeal a magistrate's decision, whether it's 105 or 113, you don't need leave. Now, there was an important case less than a year ago called Hoi Lai Ki in the CFA. And this clarified the test for appealing against a magistrate's decision. Previously, judges in the Court of First Instance were reluctant to overturn a magistrate's decision on a finding of fact, credibility, unless they could establish, or it could be established, that the decision was plainly wrong. But Hoi Lai Ki said that's not the correct test. And the reason is the provision of Section 113 talks about there being a rehearing of the evidence, supplemented by any fresh evidence, additional evidence that can be introduced. So the appellate court doesn't have to be satisfied that the magistrate was plainly wrong, illogical, or inherently improbable. There doesn't even have to be a particular error that's identified. The appellate court has to conduct a full rehearing and reach its own conclusion. In other words, they have to be satisfied that the prosecution have proved their case beyond reasonable doubt. And if they can't be satisfied at that, then the conviction should be quashed. So this is a different test now that's being applied. So if you're reading older cases that talk about the appeals court having to be satisfied that the magistrate's decision was plainly wrong, that's no longer the correct test. But this case is also good to read through because it makes the different types of appeal clear. Remember that when the CFI judge does a rehearing, he doesn't have the benefit, though, of these witnesses testifying in person again. He's just relying on what they call depositions of those witnesses, right? The statements that were made at trial. So he doesn't actually get the depositions. There are no depositions that are created. So that language is quite misleading. But what he looks at is the transcript of the trial and the findings of the magistrate, as well as what's in the appeal bundle. So he may not get the whole transcript, but he will get those parts that the parties have agreed is appropriate to go before the appeals court. So there's basically 4 different types of appeal. There's what we call appeals stricto sensu, where you have to identify an error in order for the appellate court to overturn that decision. You have appeals by way of rehearing, but only based on the original evidence that was at the trial, or you can have a rehearing when new, fresh evidence is introduced on appeal. But the Court of Final Appeal also talks about this appeal by way of a hearing de novo. That's the fourth type of appeal. In that type of appeal, the appellate court basically conducts a retrial. So the witnesses are called to testify before the appellate court. And the appellate court will reach its own findings on credibility and its own findings of fact. Now, we don't really have this appeal by way of a hearing de novo in Hong Kong, because when the appellate court hears the appeal, it's not a retrial. The witnesses are not called to testify. They have the power to order a retrial, but that retrial takes place in the original court where the proceedings were tried. So the magistrate's court, district court, or CFI, right? The CFI judge doesn't conduct the retrial in the CFI himself as part of the appeal. No, there is no appeal by way of a hearing de novo in Hong Kong. It exists in other jurisdictions, but it doesn't really exist here. But the slight sort of exception is that if fresh evidence is being introduced on appeal, then the appellate court can hear the testimony of the witnesses about that fresh evidence. So it's like a semi-little de novo, right? But generally, the Court on Appeal has the power to order a retrial, but doesn't conduct the retrial itself. Don't worry too much about this appeal by way of a hearing de novo. So the plainly wrong test that's used in civil appeals or an appeal from the district court CFI to the Court of Appeal isn't the correct test when we're talking about Section 113 appeals. Now, I said earlier that an appellant has to choose whether to proceed under Section 105 or 113. He can't do both. So which he chooses generally depends on what he's appealing. So if it's question of law, he could use 105, but from the defense perspective, they don't usually want to because it's going to cost them more money. If you look at these provisions, which you should, you'll see that the magistrate's ordinance doesn't set out what are the grounds on which you can appeal, other than just saying 105 has to be a question of law or outside of the jurisdiction. And 113 just talks about appealing against a conviction, order, or determination. So the grounds are not specified in the magistrate's ordinance, but generally you use similar grounds to the ones that exist under the criminal procedure ordinance, whether you're appealing against conviction or against sentence. So you can argue that the conviction is unsafe or unsatisfactory. It was a wrong decision in law or material irregularity, that the sentence was outside of the court's jurisdiction, manifestly excessive, manifestly inadequate, was based on wrong facts, or that perhaps the tariff or guidelines that were in place have been significantly altered since the sentence was passed, usually downward. If the tariff has been increased since the defendant was sentenced, then the court will not apply the higher tariff, right? That will not impose more years of imprisonment. But if the tariff guidelines have been reduced, which rarely happens, the defendant may be able to benefit from the reduction. So what is the scope of an appeal? Hoi Lai Ki, if you read the provisions of Section 105 and 113, they talk about a rehearing of the evidence. But Hoi Lai Ki has made it clear that actually Section 105 is not really a rehearing in the same sense as 113, because under Section 105, the grounds of appeal are limited to those stated in the case. And when you appeal, you have to state your case. And it only concerns a question of law as well. So on this rehearing, of course, the court doesn't have the opportunity to see the demeanor of the witnesses when they're testifying. So it will still be reluctant to reach different decisions on credibility. And they have to exercise caution when they're considering findings of fact that were reached based on oral testimony, because they don't have the benefit of seeing the witnesses testify live. Now, when the judge in the CFI has heard an appeal from the magistrate's court, for any appeal to go up to the CFA, you need to apply for leave, and leave can only be granted on the substantial and grave injustice limb. That's another thing that Lect clarifies. So the other possibility of great and general importance doesn't exist for magistracy appeals to the CFA. What are the powers of the judge in the CFI when he hears an appeal from the magistrate's court? He can admit fresh evidence on appeal. That's section 1181B of the magistrate's ordinance. It only refers to if necessary. If necessary, he can receive new evidence on appeal. Section 83V applies to appeals from the district court or the court of first instance, and that says the evidence shall be admitted if it's likely credible, would have been admissible in the lower proceedings. In other words, it's not excluded by any of the evidential rules. It's not hearsay. It's not prejudicial. Prejudicial effect doesn't outweigh its probative value. It's not irrelevant, right? So it still meets the test for admissibility. And it hasn't been adduced, but there is a reasonable explanation. So the court, in considering whether to introduce fresh evidence on appeal, will look at why was this evidence not introduced originally, right? I forgot about it is not going to be a good reason. It has to be a situation where perhaps the prosecution failed to disclose this evidence to the defense at the time. That's why it wasn't introduced in the original trial, but now it's come to light. Or maybe a new witness has suddenly come forward that nobody knew about at the time of the trial. So all that would be reasonable explanations for failing to introduce that evidence at trial. And you have to apply to admit it by notice of motion supported by an affidavit, which sets out your reasonable explanations why this evidence wasn't introduced originally. So it isn't a given, right? You don't have the right to introduce fresh evidence on appeal. You have to persuade the court that there are good reasons for its introduction. The CFI judge also has this power to reserve the appeal or any point in the appeal for the consideration of the Court of Appeal, or direct the appeal to be argued before the Court of Appeal. And if he does so, the Court of Appeal has the same powers that the judge in the CFI would have. Now, this is basically what I think of as an appeal that the judge in the Court of First Instance considers to be a hot potato, right? So someone throws you a hot potato, you catch it, burning your hands, you lob it, right? So this is the power of the CFI judge to say, oh, this appeal is way too difficult for me. I don't want to deal with this. I'm going to send it up to the higher court. So it's used where the CFI judge thinks that this is a particularly complex issue, or where perhaps it involves a novel, a new point of law that hasn't been argued before. So he doesn't want to risk being criticized, basically. So he sends it up to the Court of Appeal. So remember this Kelvin YC Learn case where there was this bickering, arguing between a magistrate, defense counsel, and prosecutor and solicitors and everything. What the CFI judge did here is he used his power under 1181D to be, this case is a nightmare. I don't want to be involved in this at all. I'm going to send it up to the Court of Appeal for them to deal with. And the Court of Appeal said here, it was the correct approach for the CFI judge to send it up to the Court of Appeal, given that the scope of the appeal went far beyond what was appropriate for a normal magistracy appeal. Okay, so yes, he did the right thing. The judge in the CFI can confirm the magistrate's decision. In other words, uphold the original decision, right? So dismiss the appeal. Or he can reverse or vary the decision, or direct that the trial be heard de novo by the magistrate, in other words, a retrial, or he can remit it with his opinion to the magistrate and direct the magistrate to make such order as he thinks just. Now, sometimes what you see is where the judge in the CFI gives his opinion and remits it back to the magistrate and basically says, here's my opinion, you should follow it. Sometimes the magistrate says, well, I don't want to. So they refuse to follow it. And then there's a subsequent appeal. So this power to remit with the opinion it's not always successful in practice. And he can exercise any power that the magistrate could have had, make any decision that the magistrate could have made. He also has the power to either increase or decrease the defendant's sentence, provided that the sentence is within the jurisdiction of the magistrate's court. So where the defendant's appealing sentence, you have to warn your client that one of the risks of that appeal could be that his sentence is increased. That's section 119. And the judge in the CFI can even substitute conviction for another offense, provided the magistrate could have convicted of that alternative offense. Now, substituting the conviction is either for an offense, an alternative offense of the same gravity, or a lesser alternative. The judge in the CFI won't convict the defendant of a more serious offense than the one that he was charged with. We're going to talk about the proviso in a minute, but there is no power to apply the proviso under Section 83 of the Criminal Procedure Ordinance when a magistrate's decision is being appealed to the CFI. So the proviso is basically where the court on appeal thinks that there are valid grounds of appeal, right? Something did go wrong in the original court, but they apply the proviso. And I think of it as being like, too bad, so sad. You have good grounds of appeal, but we are satisfied that there was no miscarriage of justice. In other words, you have technical grounds of appeal, but we think you're guilty. There's been no miscarriage of justice. That's the proviso. And it doesn't exist in the magistrate's court. Okay, so in other words, if there are good grounds of appeal, then the original decision will be overturned. The test is whether there's been an error which makes it just that the appeal should be allowed and the conviction set aside. So that's appeals from the magistrate's decision. Let's talk about the power to review. So remember, this is a power that only exists in the magistrate's court. There is no power to review a district court judge's or a CFI judge's decision, only a magistrate's. And when we review, we're staying within the level of the magistrate's court. Another thing that's different between a review and an appeal is you don't have to wait until the case is finished to review the decision. The whole point of the review process is it can be made at any stage during the proceedings. So if the magistrate makes a decision on the admissibility of evidence and you disagree with it, you can apply to review that decision, even while the trial is ongoing. And it applies to either the defendant or the prosecution, but also the magistrate himself can review his decision of his own motion. So let's say he makes a decision or he passes sentence, and then he goes and talks to one of his other fellow magistrates, and he realizes he got his decision wrong. He can actually review his own decision of his own motion and basically reopen the case himself. That's subsection 5. And you can review anything. It's a very broad power. You can review conviction, sentence, costs, orders, decisions of the magistrate. But where you are trying to argue that the magistrate is biased, hates your client, or that he has acted improperly in some way, or he's reached a wrong conclusion on the fact, or he's exercised his discretion wrongly, it's not appropriate to use the review procedure. Why? Because usually you go back before the same magistrate who made the decision. And if your argument is you were biased, what's he going to do? Say, yes, you're right. I'm totally biased. I shouldn't be sitting here on the bench. I'm going to step down. Of course not, right? So the review procedure works best where something obviously has gone wrong. And it's very clear that there was an error made. And for that reason, the review is likely to succeed. And you can use the 104 procedure to apply to reverse plea even after sentence has been passed. This is that decision we were talking about earlier, because the magistrate is not functus officio because of the 14-day provision in section 104. So after sentence is passed, there's still this 14-day time to review. So the magistrate is not functus, he's not deprived of his jurisdiction until this 14-day period has expired. How do you review? You can, well, you need to apply, and you have to apply in writing within 14 clear days. So clear days, day 1 is the day after the decision. No ability to extend the time. And an applicant has to make a decision. Am I going to appeal or am I going to review? Because if he commences an appeal, then he cannot review. So in practice, it may be better for the defendant to review first, provided his grounds are not bias of the magistrate, because the time to appeal doesn't start to run until after the magistrate has made that decision on the review. So you can review first and then still have the 14 days to appeal from that review decision. So essentially you're getting 2 opportunities there, right? One to go back before the magistrate, and if he doesn't agree, you can still appeal to the CFI judge, but you can't appeal first and then review. It doesn't work the other way around. Why would a review be advantageous? It's often quicker because you're going back before the magistrate who made the decision. So he's very familiar with the facts. You don't need to waste time going through the background. So that's one advantage. It's quick. It's also less costly because you're staying within the magistrate's court and you're not going up to a higher court where you may need to instruct solicitor with higher rights of audience or counsel to do the appeal. So it's quicker, it's cheaper, and you can do it at any stage of the proceedings rather than waiting until the end. So you can get a quick decision where something has clearly gone wrong and get it fixed, rather than having to wait to the conclusion of the trial and appeal it then. On a review, a magistrate has very wide powers. So he can reopen the case, rehear it in whole or in part. Although generally you go back before the same magistrate, the magistrate can actually decide that it be heard by another magistrate if it's in the interests of justice. But the magistrate can also admit fresh evidence. He can reverse, vary, or confirm his original decision. And if the review decision goes against you, you still have the right of appeal. But if you try to review before the magistrate and he says, no, I don't want to hear your review application. He refuses your request to review. You cannot appeal that refusal by the magistrate to listen to your review. That's subsection 10 of section 104. You can still appeal the original decision that he made, but you cannot review his refusal to listen to your review. You can just appeal the original decision. Yes, did you have a question? Okay, so the question is, isn't it against human nature to admit you're wrong? Generally, yes, I agree. However, in a situation where the magistrate has made a decision because he didn't have the necessary evidence before him, or he wasn't referred to the correct law by prosecutor or defense counsel, right? Or let's say like a new decision was passed yesterday by the Court of Appeal and nobody was aware of it. It's just suddenly come to light, right? So there could be situations in which the magistrate doesn't have to admit that he necessarily got the law wrong, right? Could be just that something was clearly omitted that should have been within his consideration. So that's one fact why a review may be successful. Second reason is also think about it from the magistrate's perspective. If he did make the wrong decision and it's then appealed to the CFI, what's the judge and the CFI going to say? Or even worse, it ends up in the Court of Final Appeal. And here's this damning, scathing judgment on how incompetent the magistrate was, right? It may be much better for his own reputation to just say, yes, that decision shouldn't have been made. I'm going to overturn it, right? And then chances are it doesn't hit the press when it's dealt with at a very early stage. Okay, so that's also advantageous from his perspective. So appeal or review, much cheaper to review, much quicker to review, wider powers on review, whereas the scope of an appeal under 105 is very restricted. Is it appropriate to review? Not if the magistrate was biased or exercised his discretion wrongly. And remember, if you review first, you can still appeal later because you have the 14 days from the date of the review. So most defendants will choose to review first rather than appeal. Secretary for Justice can review a sentence that was passed, but they need leave. And they can review a sentence in the MCDC or CFI using this provision of Section 81A. They can argue that the sentence is manifestly inadequate or manifestly excessive. Now, why would the SJ ever want to argue that a sentence passed on a convicted defendant was manifestly excessive, right? Go back to the general duties and roles of a prosecutor, right? Not to secure a conviction at all costs, to act as a minister of justice, to be impartial and independent, right? So their objective is not to seek the highest possible sentence that could be imposed, but the reasonable sentence given the circumstances of the case. So sometimes they will appeal on the basis that the sentence was manifestly excessive. Rare, but they do sometimes. Or they're arguing that the sentence was wrong in principle or didn't exist in law. They have to appeal within 21 days in writing, but there is the power to admit fresh evidence as well under 83B. If the court, by the way, does increase the sentence on appeal, right? So it thinks that the sentence was manifestly inadequate, so it increases the sentence on appeal, usually to reflect the fact that the defendant originally thought he was getting a more lenient sentence. What they will do is they will say what the appropriate sentence should have been, and then they will give some reduction on that to reflect the fact that the sentence is being increased on appeal. And I think you can read this next slide yourself. Juveniles have the right to appeal as well. The provisions of the magistrate's ordinance apply. Remember that a juvenile could be convicted in another court. Remember, we looked at section 3C of the Juvenile Offenders Ordinance, whereby if they are tried jointly with an adult, or if the circumstances of the case are similar to charges against an adult, they may be sent up to another court, maybe the magistrate's district court or CFI. If that occurs, then the provision in section 3F of the Juvenile Offenders Ordinance says that usually the other court that's convicted the juvenile should remit the juvenile to the juvenile court for sentencing. The reason is so that the juvenile could benefit from those wider sentencing powers that the juvenile court has. But they still have the same rights of appeal that they have in the court where they were convicted. So that's appeals from the magistrate's court to the CFI under 105 and 113, and reviews within the magistrate's court under 104. I think what we'll do now is it's 8:22. Let's take a break. Let's see. Yeah, I think we'll take a break now because we're about to move on to appeals from the district court and CFI. So let's take a break until 8:30, just less than 10 minutes, and then we'll come back. We'll deal with the rest of the slides, and then I have a couple of questions just to test your level of knowledge so far. Okay? Okay, let's talk about appeals from district court or CFI to the CA. Prosecution, we can see the options set out in the summary table here. Quite a lot of options for the prosecution, but the defense also has quite wide abilities to appeal against his conviction or sentence. So let's talk about each of the different options. The prosecution can appeal by way of case stated under Section 84 of the District Court Ordinance against a defendant's acquittal in the district court. This provision, though, obviously only applies where the trial is in the district court. It doesn't apply to a trial in the CFI. It has to be an appeal on a question of law, and it's only against a defendant's acquittal in the district court. So it's not available for a defendant to appeal his conviction, only for the prosecution to appeal the defendant's acquittal. Now, when you read Section 84, subsection C, the powers of the Court of Appeal are to dismiss the appeal, reverse the verdict, and direct the resumption of the trial or a retrial, or find him guilty, record a conviction, and pass such sentence on him as may have been passed on him by a judge. If we were just to rely on the statutory provision alone, we would think that the Court of Appeal could overturn the conviction, overturn the acquittal and convict the defendant. That is not the case. So this is a good example of where case law has intervened to find a statutory provision as being unconstitutional. So you can never just rely on a statutory provision itself. You have to look to see how case law has interpreted that statutory provision, or sometimes even held it to be invalid. So the case here is Wong Sao Fong. So the defendant was acquitted in the district court, and the issue was, could the Court of Appeal overturn the acquittal and convict the defendant? And they said that this provision in subsection 2 was inconsistent with the Bill of Rights. Why? Because if they did convict an acquitted defendant, there is no right of appeal to the Court of Final Appeal, right? In order to appeal to the Court of Final Appeal, you have to meet this very high threshold, and you have to get leave to appeal. So if they convicted him for the first time, there would be no right of appeal. And that is a constitutional right set out in the Bill of Rights. So the conclusion is, the Court of Appeal does not have the power to record a conviction and sentence the defendant where he was acquitted in the original trial. But it can overturn the acquittal. It can direct a retrial or for the trial to be resumed. Let's say that the defendant has been acquitted at the no case to answer stage, or the prosecution maybe has offered no evidence at some point during the trial. So the Court of Appeal can overturn that and direct the trial to be resumed, or it can order a retrial, but it can't just convict for the first time. So, in conclusion, Section 84 District Court Ordinance means that if the defendant is acquitted in the district court, it's not final. The Court of Appeal can overturn it, but not in such a way that they convict and sentence themselves. They have to send it back. If they overturn the acquittal, it has to go back to the district court. Now, the prosecution only has 7 clear days after the acquittal to make this application. Not much time at all, but there is the possibility of an extension of time. So that's the power for the prosecution to appeal against the acquittal in the district court. If the defendant is acquitted in either the district court or the CFI, Section 81D provides that the SJ can refer a question of law to the Court of Appeal. This is not really an appeal. This is a reference on a point of law because it doesn't affect the original acquittal. In other words, if the defendant is acquitted and this provision is used, the acquittal cannot be overturned. The acquittal stands. This is just a reference on a point of law for the Court of Appeal to give an advisory opinion for future cases. So if a jury in the CFI has acquitted the defendant, that acquittal is final, cannot be overturned. All that the SJ can do is refer a question of law to the CA, for the CA to reach an opinion for future cases. But the defendant can run out of the courtroom door, whooping and high-fiving his team, he's home free, if the jury acquits. If he's acquitted in the district court, Section 81D also applies, but remember, it doesn't overturn the acquittal. It's only a reference on a point of law. So what that effectively means is that because the prosecution have much wider powers under 84 DCO than under Section 81D of the CPO, they would tend to rely on Section 84 district court ordinance, right? If they want to overturn the acquittal, rather than just referring a question of law. But that's from the district court, right? If they want to do something about the acquittal by the jury in the CFI, well, too bad, they can't overturn it. The most they can do is just seek clarification on a point of law. This provision, next, Part 4, Division 6 of the CPO, has only been added in the last year and a half. Because there is no right to appeal an acquittal by a jury in the CFI, this provision was introduced to cover cases of national security where there was an acquittal by the panel of 3 judges. So in that situation, the SJ can appeal the acquittal by the panel of 3 judges in the CFI. But it has to be on a question of law, and they only have 14 clear days to do it. So this fills a bit of a gap in the law. You can now appeal an acquittal by the panel of 3 judges in a national security case. But so far that hasn't happened. No one's been acquitted by the panel of 3 judges. There is still criticism of the fact that you can't appeal a jury acquittal. So there are calls for the law to be further reformed to give the SJ the power to appeal a jury acquittal. But so far, that hasn't been done. Actually, when the jury render their verdict, right, not guilty or guilty, you never find out the reasons on which they've decided. Well, that's all you get, guilty or not guilty, and you get to find out whether it's unanimous or what the majority was. But you never find out the reasons, right? They deliberate in secret and their reasons are never revealed. In Hong Kong, it's not like in the US, where after the trial is finished, all of the jury members are interviewed by like the television networks and they talk about why they reached their decision, or they do like documentaries years later and they ask them to reconsider their original decision based on new evidence that's come to light. Doesn't happen in Hong Kong. So we never know on what basis they've reached their decision. And the powers under of the Court of Appeal, when hearing an appeal against an acquittal by the panel of 3 judges, they can dismiss it, dismiss the appeal, reverse the verdict and order, direct a resumption of the trial or a retrial, right? Like the case law has interpreted Section 84 of the DCO, they don't have the power to convict and sentence themselves in the CA. At most, if they overturn the acquittal, they can send it back to the original court. Some other methods of appeal here, or review of the sentence. I think you can look at these yourself. What about the defendant, the right of appeal? Section 82 of the Criminal Procedure Ordinance, if he's convicted, he can appeal against his conviction in the district court or in the CFI. He can even appeal his conviction if he's originally pleaded guilty. Why? Because the language of Section 82 doesn't prevent him from doing it. Remember, the language of Section 113 specifically stated if he pleaded guilty, he couldn't appeal his conviction. But there's no similar language in Section 82. So he could, but he'd have to show his plea of guilty was unsafe or unsatisfactory. Does he need leave to appeal his conviction? If he's appealing on a question of law, he does not need leave. But if he's appealing on a question of fact or a mixed question of law and fact, then he does need leave, unless a certificate of fitness for appeal is granted. So what's the difference between a question of fact and a question of law? Question of fact is where your grounds of appeal refer to issues of fact, right? So were his fingerprints on the murder weapon? Were the premises residential or commercial that were burgled? Did he make a confession? Those are questions of fact. But most grounds of appeal involve either questions of law or mixed questions of fact and law, right? Because if we're appealing about the voluntariness of a confession, right? It's a mixed question of law and fact. Let's say that the defendant is saying, I didn't confess, right? Now that's a question of fact. Did he confess or did he not, right? But if the argument is, I didn't confess and the police say that they beat me up, that's also a question of fact. But if we go on to say, was the correct test applied? Should the confession have been inadmissible because it was involuntary, etc.? That's a question of law. So usually the grounds of appeal are mixed questions of fact and law, and therefore you need leave to appeal. So if you don't need leave, you can use Form 8. If you do need leave, you use Form 11. What grounds can you appeal on? They're set out in Section 83. So the conviction is unsafe or unsatisfactory. Now, what you will find about these grounds of appeal under Section 83 is they overlap quite substantially. So you may read some cases in which they've decided that failing to do something rendered the conviction unsafe or unsatisfactory. You may read a different case in which the same failure to do something is called a material irregularity. So there is a great deal of overlap. If there is a lurking doubt, a general unease about the verdict, that would make the conviction unsafe or unsatisfactory. Or if there has been excessive judicial intervention, a judge can ask some questions of the witnesses in the case to clarify uncertainties or to make sure he's correctly understood the evidence. But what the judge cannot do is descend into the arena of counsel, take over counsel's role, make improper suggestions in questioning the witness, prevent the witness from answering the questions. That would be excessive judicial intervention. So have the judge's questions caused an informed bystander to conclude that the defendant did not have a fair trial? That's the test that's used. So it's a question of fact in the circumstances of the case as to whether the judicial intervention was excessive and renders the conviction unsafe or unsatisfactory. Where the judge is biased, for example, that may render the conviction unsafe or unsatisfactory. Would a fair-minded and well-informed observer conclude that there was a real possibility that the judge was biased? Remember that justice not has to be done, but must be seen to be done. So they quite often use this well-informed, fair-minded observer test. What about where there's been misconduct by the prosecution or by the police or the ICAC, for example? That could be a ground to render the conviction unsafe and unsatisfactory. And I referred to this Chunto Raymond case when we were looking quickly at applications for a permanent stay of proceeding. In this case, the misconduct by the ICAC officers did render the conviction unsafe and unsatisfactory, but they ordered a retrial because these charges were very serious. Flagrant incompetence by counsel can also be a good ground of appeal, but this ground should only be used in exceptional circumstances, and there's a very high threshold for it to be successful. It's not just counsel made a mistake or made a wrong tactical decision. The threshold's very high. It has to be flagrant incompetence. For example, deliberately ignoring instructions from his client. That would be flagrant incompetence. So it should only be made in the most exceptional circumstances, not just about a tactical decision. Failing to properly evaluate the evidence. This really also overlaps with the summing up being unfair and unbalanced. We'll talk about that in a minute. But if there has been an error of interpretation during the trial, and as a result, that's caused the judge to wrongly misdirect the jury, then that could also render the conviction unsafe or unsatisfactory. So I think you can read this in Pat Malone case. Where the judge sums up the case to the jury, the overriding requirement is that it's fair and balanced. And what that means is he has to evaluate the evidence from both sides, not just focus excessively on the case for the prosecution and be overly critical of that for the defense, or he cannot omit material aspects of the defense case in summing up the case to the jury. Here, in this case, Huang Roy Fang, not only was the judge's summing up unfair and unbalanced, because he concentrated on the prosecution case and he didn't refer to material parts of the defense case, but it was also inaccurate. He got the facts wrong and the evidence wrong when he was summing up the case to the jury. So for that reason, there was a miscarriage of justice. And this case is generally considered one of the leading cases, Jitsata Shosita. The judge failed to maintain a balance in his summing up by reminding the jury of the key points of the prosecution case, but failing to remind them of the essence of the defendant's explanations. So in Hong Kong, the test is the conviction unsafe or unsatisfactory? There's actually no real difference between those two, unsafe and unsatisfactory. If the conviction is unsafe and unsatisfactory, then the proviso in section 83 that we're going to go on to look at in a minute does not apply. Because if the conviction's unsafe or unsatisfactory, there must have been a miscarriage of justice. So the Court on Appeal cannot apply the proviso. Wrong decision in law has to be material, has to have affected the outcome of the trial. So misdirecting the jury, making a wrong decision on the admissibility of the evidence, wrongly exercising your discretion are all wrong decisions of law. So zo li mei. But it has to be a material wrong decision in law, right? Not just every wrong decision that's made. Material irregularity in the course of the trial, significant as it substantially impacts the issues to be resolved or is capable of affecting the outcome of the trial or depriving the appellant of his right to a fair trial. So things like wrongfully exercising discretion, but that can also be a wrong error of law. In wrongly allowing the introduction of evidence. Again, that could be a wrong decision of law. Where the prosecutor refers to inadmissible prejudicial evidence in opening, then that's a material irregularity. So referring to hearsay information, that's very serious professional misconduct. And when it happens in opening the case, usually it results in the trial being abandoned and a retrial being ordered. Referencing the fact that the defendant is a target of a police investigation. The term target is actually very prejudicial because it suggests that the police are already acting upon information that they have. So by using that term target, it reinforces the strength of the prosecution evidence. So target shouldn't be referred to by the prosecution. And I put a recent case here for you, Shakil Ahmed, because this is a case in which it wasn't the prosecution or the judge who wrongfully used the term target. It was actually defense counsel themselves. And defense counsel did it on a number of occasions. And then on appeal, they tried to argue that the term target had been prejudicially introduced, and that would be a good ground of appeal. Clearly, it was a different counsel on appeal than at trial. But the court on appeal weren't satisfied by that argument, right? Because it was the defense who introduced it in the first place. So it was a tactical decision to show that the defendant had been framed. And it couldn't be argued it was prejudicial because that was a part of the defense case. So he was basically saying, you unfairly targeted me and you framed me. That was the defense. And then I've just put some other examples for you of what amounts to material irregularities. Hazeltine, this deals with a situation where the defendant had offered a guilty plea to a lesser offense. It wasn't accepted by the prosecution. And then at trial, he ended up being acquitted of the more serious offense, but convicted of the less serious offense, not based on the evidence of the prosecution, but based on his guilty plea. And remember, if he pleads guilty to a lesser offense and the prosecution don't accept it, that guilty plea to the lesser offense is a nullity. It cannot be used to convict him. He can only be convicted of the lesser offense based on the evidence produced at trial. But where the prosecution failed to disclose material information, this is a good ground of appeal as being a material irregularity. Or misdirecting the jury. This is an interesting one. It's a recent case, Learn Why Kit. In this case, the defense counsel had failed to what we call put the defense case to the prosecution witness. We remember from evidence law, there's the rule in Brown and Dunn, right? The rule in Brown and Dunn says that if in your closing, you intend to argue that a material aspect of the prosecution case is not correct, then you must put that to the prosecution witness and give them the opportunity to deny your assertion. And if you fail to comply with the rule in Brown and Dunn, then you can be prevented from making that argument in your closing. So if your defense case theory is that the prosecution witness is a liar, the rule in Brown and Dunn says, in cross-examining that prosecution witness, you have to put it to them. Mr. Wong, I suggest to you, you are not telling the truth. You are lying to the court. That's putting your case, giving them the opportunity to deny that assertion. And if I don't put my case, I cannot argue in my closing as a surprise to everybody that he's lying. In Learn Why Kit, though, the defense counsel failed to put part of the defense case to the police officer. And when the judge was summing up the case, he highlighted the fact that defense counsel hadn't put this case. And he suggested that as a result, the defense was not credible. And the Court of Appeal are critical of that because they say there may be reasons why defense counsel doesn't put the case. May not be just because the defendant's explanation is not credible, maybe because defense counsel's incompetent or they forgot. So the judge shouldn't reference the failure to put the case in the context of the defendant's explanation not being credible. So as you can see, the grounds of appeal frequently overlap. Just be careful if you're reading cases post-1995 from the UK, because the law has been changed. So there's now only one ground of appeal, which is that the conviction is unsafe. Our situation in Hong Kong is based on the old UK position of having these three different grounds of appeal. The reason the law was changed in the UK is because there was so much overlap between these different grounds of appeal. And they felt that a ground of appeal, just that the conviction was unsafe, really covered everything. So what do we mean by the proviso? When you have looked at the grounds of appeal in section 83, the next paragraph goes on to say, provided that the Court of Appeal may, notwithstanding that it's of the opinion that the point raised in the appeal may be decided in favor of the appellant, dismiss the appeal if it considers there has been no miscarriage of justice. So too bad, so sad. You technically have good grounds of appeal, but we are satisfied, no miscarriage of justice. And here's the test from the Kulanethan case. If a reasonable jury properly directed would, without doubt, have convicted or inevitably have come to the same conclusion, then the appeal may be disallowed. But remember, if the conviction is unsafe or unsatisfactory, you cannot use the proviso. So the proviso only applies to a wrong decision in law or a material irregularity. Because saying that the conviction is unsafe and unsatisfactory and the proviso are two sides of the same coin. And the proviso only applies to appeals to the CA, right? Not to magistracy appeals. So what can the Court of Appeal do? Well, it can overturn a finding of fact, but it will do so reluctantly. It can substitute a conviction of an alternative offense. And then I think this bit here, there's some errors here. So what I'll do is I'll revise the slide and I'll get Bessie, there's just some typos. I'll get Bessie to post up the revised slide for you. Basically, what this slide should say is they can substitute conviction of an alternative offense, but only one that the defendant could have been convicted on at the evidence at trial. Okay? And they can increase the sentence on appeal as long as it's a sentence that could have been passed at first instance. And they can order a retrial in the interest of justice. Right? So I think as I was amending the slide, I've mistakenly chopped out some words and put some words in the wrong place. So I'll fix that and I'll get Bessie to post up the revised slide. CA or CFA can also order a retrial. Relevant factors, obviously they're more likely to order a retrial for serious offenses. But if there's been a long delay that's elapsed, that may be one factor that works against the retrial, right? Because if evidence has been lost or witnesses have died or disappeared in the meantime, there may no longer be a reasonable prospect of conviction, right? There may be insufficient evidence, or maybe it's not even in the public interest to prosecute anymore. But the more serious the offense, the more likely it is that a retrial would be ordered, like Nancy Kissel, for example. The defendant can appeal his sentence under Section 83G unless the sentence is fixed by law. On what grounds? Either outside the jurisdiction, wrong in principle. Wrong in principle means the wrong type of sentence was imposed. So the argument here would be, let's say he was in prison, but the argument is Section 109A applies because he's a young offender. So the court should have looked to a rehabilitative option. And in fact, probation was recommended. So the wrong type of sentence was imposed. Or the sentence is manifestly excessive. Based on the wrong facts, the judge took irrelevant facts or wrong facts into account when he sentenced. Or the tariff has been significantly altered downwards since the time he was sentenced. So manifestly excessive, right? Not just a little bit high, because remember, a sentencing judge has a wide discretion. So in order to be manifestly excessive, it really has to be outside of the discretion of the sentencing judge. This is just a reminder here that in order for a defendant to benefit from a reduction in his sentence from giving assistance to authority, he has to have actually given that assistance. So if all he's doing is saying, I'll offer to help in the future, that will not give him a reduction in his sentence. If he's been convicted and sentenced, though, and then subsequently he does offer useful assistance, right, which results in the arrest or conviction of other people, he gives information to the police they weren't aware of, then he could appeal his sentence and try to seek a reduction, right? But where the court is aware that the defendant is intending to give assistance, because they won't reduce based on a promise to give assistance in the future in case he doesn't, what they usually do is adjourn sentencing, because they want to avoid the situation where he's sentenced, then he gives the assistance, then he has to appeal, then they have to go back and undo what was done. So it's better to just adjourn the sentencing until he's given that assistance, and then everything can be dealt with at the same time. You always need leave to appeal sentence. And the court on appeal can quash the sentence, impose another sentence. So they may impose a different type of sentence, or they can increase the sentence or decrease the sentence or dismiss the appeal. How do you appeal to the Court of Appeal? You have 28 days to appeal from the date of conviction or from the date on which sentence was passed. But if sentence is passed more than 7 days after conviction, then you have 28 days from the date on which sentence was passed to appeal. And you can get an extension of time, but when does this 28 days start to run from? It's actually not clear in the Criminal Procedure Ordinance. You actually have to look at section 71 of Cap 1, Interpretation and General Clauses Ordinance, to tell you. So what that basically says is it's exclusive of the date on which something happens. So in other words, the 28 days starts to run from the date after conviction or sentence. So the day of conviction and sentence is like day 0, day 1 starts the next day. Now, if the 28th day is a public holiday, let's say day 28 is December 25th, it goes forward to the next day. But December 26th is also a public holiday. So it goes forward to the next day. That's not a public holiday. Okay, so just bear that provision in mind, because if you're calculating your deadline to appeal. You need to file your notice of appeal, either Form 8 if you don't need leave, or Form 11 if you do need leave. You file your initial grounds first, and then you perfect them later when you have the transcript. CFA appeals, you always need leave, either from the CFA or a certification of fitness to appeal, point of law of great and general importance, or substantial and grave injustice has been done. You've got 28 days to apply. You can get an extension of time, but there's a very high threshold to appeal. And the Court of Final Appeal has often said it's not a second court of appeal, right? It's very rare for a case to make itself up to the Court of Final Appeal. But if it does, it can order a retrial, reverse, confirm, or vary any decision. If the CFA decision goes against you, then you're stuck. There's no further right of appeal. They are the final level of appeals court. They replace the old Privy Council in the UK. But of course, we know that it's possible there could be a reinterpretation of the law, right, by the NPCSC. So that has happened at least 3 times in our history that the NPCSC has reinterpreted the law. Things to talk to your client about if you're considering appealing. You have to warn him that the sentence could be increased on appeal. You have to warn him that he could be sanctioned by losing time spent on remand, right? General principle, time on remand counts towards his release date. But if he brings an appeal without merit, one sanction the Court of Appeal can impose is that he loses the time that he's spent in custody between the filing of the appeal and the appeal date. But this is really just an exceptional circumstance. Yes. If sentence is increased by the court on appeal, it would usually be because the magistrate wrongfully exercised his discretion, right? Or the sentence was manifestly inadequate in some way. It's not done as a punitive sanction for the defendant, because obviously it's nothing to do with the defendant what sentence is imposed. So what the court usually does is, if it's imposing a harsher sentence, it will look at, let's say, what the defendant has done so far. And sometimes it will indicate, look, the court below got it wrong. We think that the defendant should have been sentenced to 18 months in prison, but actually he was given community service. He shouldn't have been. The sentence was manifestly inadequate. But because he's already served all of that 240 hours of community service, we decline to increase his sentence, right? So that's what they do sometimes. Or sometimes they say, he should have been sentenced to 18 months imprisonment. He got 6 months, but because he had the expectation that he would only get 6 months, although we think 18 months should have been imposed, we'll reduce it by 3 months to reflect the fact that the sentence is being increased on appeal. So they don't usually take a punitive approach. You have to think about whether to admit fresh evidence on appeal. You can possibly get an extension of time if you've got good cause, but you also need to think about bail pending appeal, right? Remember, magistrate can grant bail pending appeal. CFI judge can grant bail pending appeal from an appeal from the magistrate's court to the CFI, or the Court of Appeal can grant bail pending appeal, where the case is being appealed from the district court or the CFI, but a district court CFI judge cannot grant bail pending appeal to the CA. The overriding test, though, for bail pending appeal is, there's two limbs. Would a substantial part of the sentence have been served by the time the appeal has been heard, or that the appeal has substantial merit? But where the sentence is very short, it doesn't mean that the defendant will get bail pending appeal just because he's only been sentenced to 2 weeks in prison and it's going to take 2 months for the appeal to be heard. The overriding consideration is whether the appeal has substantial merit. So if the appeal does not have substantial merit, then the fact that his sentence is only a short one will not get him bail pending appeal. And in practice, usually you file your notice of appeal first, and then you apply for bail pending appeal on the back of the notice. But sometimes you may be able to persuade the court to accept an undertaking that an appeal will be filed in order to grant bail pending appeal. And then this last slide, you can appeal a cost order as well, or a refusal to give costs, except if you're in the district court and the defendant's been acquitted. There's no statutory provision. The only option there is for the defendant to judicially review the refusal to give him costs. Okay. Any questions? Sure. So the question is, are mitigating factors useful for a mandatory sentence? Yes, in the sense that, let's say we're talking about section 33, possession of an offensive weapon, and the defendant is aged between 17 and 25, right? So there's the option of maximum 3 years imprisonment, or there's detention center or training center. Where mitigating factors are relevant is if the sentence of imprisonment is imposed, right? They may reduce that sentence of imprisonment from the starting point. But mitigating factors also sometimes may persuade the court to impose a more lenient type of sentence, right? So perhaps the defendant gets training center versus imprisonment, right? Although we talked about how in practice, that's not always considered. a lenient sentence, but technically, in the eyes of the court, it's a more rehabilitative option. So mitigating factors have an impact not just sometimes on the length of imprisonment, but also on the type of sentence that's imposed, right? If the defendant is in ill health, if he's about to die, you may be able to persuade the court to impose a non-custodial sentence, right? Based on the ill health. So it can affect the type as well as the length. Okay, so let's do a couple of questions on okay, so you go to menti.com, use the code 64423775. 64423775. So this is a recap really on lectures 4, 5, and today. So a voir dire is available in the MC, DC, and CFI. You were quick enough, you'd have seen the answer before I flicked off the slide. Correct answer is actually true. You can have a voir dire in all levels of court. It's just that in the magistrate's court and district court, to save time, they usually use the alternative procedure so that the evidence on the admissibility of the confession is heard at the same time as the evidence on the general issue of guilt. The special issue of admissibility is not separated in the alternative procedure. In the voir dire, you have a separate mini trial on the special issue of admissibility. It can happen in the MC and DC where all that the prosecution have is, say, the defendant's confession. So they may have a voir dire because if the confession is ruled inadmissible, that's the end of the case. They have no other evidence. So it's technically possible, but usually it's the alternative procedure. Test on a no case to answer submission is A, whether the defense case taken at its highest is such the defendant could not be convicted. B, whether the prosecution has proved its case beyond reasonable doubt. C, whether the prosecution case taken at its highest is such that no jury properly directed could convict. Correct answer is, we have some people making a last-ditch surge for A. No case to answer submission. Remember, it's the defense who makes the submission, but the test that's applied at the halfway stage is whether the prosecution case taken at its highest is such that no jury properly directed could convict. That's a much lower standard on the Galbraith test than whether it's proved its case beyond reasonable doubt. So A is wrong because it's not the defense case that's taken into consideration. B is wrong because that's the test at the end of the trial. The correct answer is C, at the halfway stage, the Galbraith test, a much lower standard. Bail is not possible pending the preparation of a DC report. True, the ordinance does not allow it. False, the ordinance does allow it, and in practice, the defendant will usually be granted it. False, the ordinance allows it, but in practice, defendant will never get it. Correct answer is C. Technically, it's possible because it says that the defendant may be remanded in custody pending the preparation of the report. But in practice, we'll never get it. Why? Because the intake officer, in order to determine if he's suitable for the detention center, has to have him there, right? He has to have him there for the 2 weeks to see if he can comply with the rules in the DC. A doc ID should never be permitted in court. True, it's very prejudicial. False, the defendant is in the dock for a good reason. Or C, it depends. Sorry. It depends. Doc IDs are permissible sometimes, e.g. true recognition cases or where ID is not an issue. Should we ever allow a doc ID? Too easy for you guys. Sometimes permissible. Sometimes we don't need to object to it because identification is not an issue, right? They are known to each other, or the officer can testify in court that the person in the dock is the person he arrested. Remember the case of Christie. Section 65C admitted facts are conclusive evidence. False, since the parties agree on them, they can always retract. True, the ordinance says so, or I've never heard of Section 65C admitted facts. Hopefully, that's not true. Correct answer, of course, yes. Conclusive evidence, stay with you on an appeal, on a retrial, very difficult to withdraw. It's always possible to appeal a sentence passed. True, this is a defendant's constitutional right. True, always possible, but the question is, should you? Or false, some sentences cannot be appealed. Remember the poor, unfortunate PCLL students who did not know the law on the sentence for murder. Is the sentence for murder appealable if the defendant is 18 or over and convicted of murder? Can he appeal his sentence? Say, I've got good mitigating factors. I'm just young, in health. False. Some sentences cannot be appealed, right? Because they're fixed. No ability to appeal a fixed sentence. A suspended sentence of imprisonment is possible for drug trafficking. True, the maximum is life imprisonment. False, it's an accepted offense. No idea, have we talked about this before? To be fair, you haven't talked about it. I've talked about it for sure. False, it's an accepted offense, right? Remember to look at Schedule 3 of the CPO, accepted offenses. Not only does Section 109A in relation to young offenders not apply, but also Section 109B in relation to suspended sentences does not apply to accepted offenses. Every judge or magistrate can grant bail pending appeal. True, the presumption of innocence means there's an entitlement to bail. False, district court judge cannot grant bail pending appeal. False, a magistrate cannot grant bail pending appeal. So B is the correct answer. Remember, no power in the district court ordinance to grant bail pending appeal, but a magistrate under the magistrate's ordinance can grant bail pending appeal. And the CFI judge can grant bail from where the appeal is from the magistrate's court to the CFI. DC is an option for a female defendant aged between 14 and 26. True, it's up to the judge. False, the DC is only for men aged 14 to 26. False, the DC is only for men between 14 and 25. Yeah, it is C. 14 to 25. Defendant can never appeal his conviction where he pleaded guilty. False, he can appeal under Section 82 CPO in the district court or CFI. True, what's done is done. False, he can appeal under Section 105 or Section 113 in the magistrate's court. Ooh. This is a test of who was paying attention today. Most people have gone with option C. He can appeal his conviction where he pleaded guilty under Section 105 or Section 113. Think about Section 113, subsection 1. Can a defendant who pleaded guilty in the magistrate's court appeal his conviction? Remember the wording of Section 113(1), subsection 1, MO, says where a defendant has not pleaded guilty, he can appeal his conviction. So the correct answer is actually A. Well done to the 8. You were correct. So he can appeal his conviction in the DC or CFI even if he pleaded guilty. Why? Because there's no, well, it's too late now. You can't jump in and add your answer after I've told you the answer. That's cheating. The extra 4 people, you've cheated. You don't get the marks. Stop. You can only appeal your conviction in the magistrate's court if you pleaded not guilty, right? If you pleaded guilty, you have to reverse your plea, apply to withdraw it. Since there's no inherent common law right of appeal, leave to appeal is always required. True? False. Leave is not required to appeal mixed questions of law and fact. False. Leave is not required to appeal a magistrate's decision or a question of law to the CA from the DC or CFI. Correct. The answer is C. Presumption of innocence means an acquitted defendant gets his costs. False. An acquitted defendant does not have to pay the prosecution costs, but he has to pay his own legal costs. True, it's the prosecution's fault for prosecuting him in the first place. Or C, it depends. An acquitted defendant can be deprived of his costs in certain circumstances if he's acquitted on a technicality or if he brings suspicion upon himself. Correct is C. The proviso in Section 83 can be applied whenever an appeals court is satisfied there's no miscarriage of justice, cannot be applied in respect of a magistracy appeal to the CFI, can be applied in respect of all of the grounds of appeal in Section 83. Ooh, most people think A, but are they right? Correct answer is B. Remember, the proviso does not apply to magistracy appeals. Too late. Defendant always gets a 1/3 discount on a sentence of imprisonment if he pleads guilty. True, he saved the court's time and costs. True, as long as he pleads guilty before the trial begins. False, he must plead guilty on the first available opportunity. Correct answer is C, right? 1/3, there's no entitlement, but he will usually get it if he pleads guilty on the first available opportunity. A defendant's acquittal can always be overturned. True, that's why we have appeals courts. False, it cannot be overturned where defendant is acquitted in the CFI by a jury. False, it cannot be overturned where defendant is acquitted in the DC or CFI. Yeah, obvious answer is B. We know jury acquittal, CFI, final. If a magistrate refuses to review his decision under Section 104 MO, no power to appeal his refusal to review. You can only appeal his original decision. Of course, you can appeal his refusal. He's being unreasonable. Say what? Answer is, of course, A. So, I have one more quick quiz to do. We have done, hold on a second. Yeah, here we go. We've done some of these questions already, but just to end, because I know you're worried about your bail applications, let's do one more quick one. So menti.com, you have to exit out, input the new code 13446597. So 13446597. Hang on to the seat of your pants. Will you survive your first bail application? So I tried to make these questions a little bit practical as well. So who is more likely to get bail? Defendant, sorry. Can you actually put your answers in? No, let's just present it first, sorry. Okay, who is more likely to get bail? Defendant A, who can only offer $100 cash bail, or defendant B, who can offer 100 million? Easy one, B can offer way more moolah. Moolah is cash, right? I think A, she'll get the magistrate's sympathy vote, or C, it depends. Is it impossible to get bail for a client who can only offer $100? What would you say to the magistrate in those circumstances? The magistrate said, $100? Are you serious? Are you insane? What would you say? Yeah, it may seem a small amount, Your Worship. However, For Miss A, it is a significant sum. She has worked 50 years of her life, and her entire life savings are $150, right? You can always persuade the court. So correct answer, it depends. Can a defendant give a recognizance of bail? Of course, he can make whatever promise he likes. Yes, the grant of bail means he has to give undertakings. No, only a surety can. We did this the other night, so we know only a surety can give a recognizance of bail. If the defendant offers to surrender his travel documents, can he keep his passport that will expire in a month? Of course, it's useless anyway, since he can't travel on it. You always have to have like 6 months validity, right? What the court doesn't know can't hurt it. No, he must surrender all his travel documents. Yeah, if it's valid, even if it's about to expire, he has to surrender it. He could still technically leave Hong Kong on that travel document, right? He may not be accepted in the other country he's going to, and technically the lady at check-in or man at check-in should stop him, but sometimes not. So the correct answer was C. If he has to surrender all travel documents, must he give up his ID card? No, he needs it for traveling to Macau. Yes, if he keeps it, he can still abscond to Macau. No, he needs to keep it or he commits a criminal offense. We did this the other night. Where defendant undertakes to reside at a specific address as a bail condition, defendant's counsel should orally inform the court of his address. Seems sensible? Yes, all parties are on the same page. Obviously, no. Privacy, confidentiality, safety. Let's not kill someone by revealing their address in open court. Defendant lives and works in Chim Sa Choi. He agrees to report to the police station. TM is the magistrate, imposes a condition that he report to Wan Chai station. Should you agree? Yes, agree to anything to get bail. Yes, it's a valid bail condition. No, there's a better alternative. So, Your Worship, the reason I proposed Chim Sa Choi police station was because Mr. Chan lives and works close by. May I urge you to consider allowing him to report to Chim Sa Choi police station. Don't say he doesn't want to report to Wan Chai. Defendant undertakes not to interfere directly or indirectly with the prosecution witnesses. He wants to apologize and write PW1 an apology letter. Is this okay? Yes, an apology is also always helpful. B, of course, as long as he doesn't threaten her. No, he would be in breach of his bail condition. If he undertakes not to interfere directly or indirectly, he cannot contact at all, right? Even if he wants to apologize. But if he's been convicted, in mitigation, you can offer his apology as when you're mitigating for sentence, right? It's a mitigating factor. D is age 70, charged with shop theft of beer at 2 a.m. Is a curfew appropriate? No, he's way too old. Yes, out late drinking at his age, he deserves it. Or C, no, he's a total rock star. I hope I have his stamina at his age. Yeah, probably, I mean, either A or C could be appropriate, right? But technically, the correct answer is A, right? He's just too old. D is convicted after trial in the DC, plans to appeal. Can the DC judge grant him bail pending appeal? We know this already, right? You must be joking. No chance is the correct answer. My client has no sureties. I feel really bad for her. She's a single mother with 2 young children. She promises me she will not abscond. Should I agree to be her surety as her lawyer? Yes, as her lawyer, I have a duty to act in her best interest, and that means getting her bail. Yes, if the other option is I have to babysit the kids. Yes, I'm going to be a surety. I don't want to babysit her kids. No, I must put my own reputation first. Of course, professionally, the answer is C. Um, if if the court is aware that she's now, or the court is refusing bail, right? So she's remanded and there's no one to care for the children. That's something as counsel you should anticipate, right? So you may be able to propose alternative relatives to take care of the children, but you have to be prepared for the situation where the magistrate will ask, has anyone contacted the social welfare department to arrange to take care of these children? Yeah. So if you hope to persuade the court not to have them taken into the custody of the social welfare department, you have to be prepared with good reasons why. Like, is there some kind of temporary guardianship order in place? Right. Like I have permanent guardians for my kids, but I also have temporary guardians in case my permanent guardians can't get here quick enough. Right. And it's something a lot of parents did during COVID, because they were concerned that if they came down with COVID and they got sent to the hospital, then their kids would be taken into custody by social welfare department. And if their permanent guardians were overseas and not Hong Kong permanent residents, prohibited from coming into Hong Kong, then you could have the kids in custody of social welfare department for a long time. So a lot of people drafted temporary guardianship orders then. So defendant surrenders his passport, undertakes not to leave Hong Kong. He gets bail. His mother dies. Defendant tells you, his lawyer, he's going to her funeral in the UK. What do? Tell him to watch it on Zoom. See if it's possible to vary his bail conditions. Tell him if anyone asks, you'll pretend you didn't hear that. C, no. B, vary his bail conditions. You have to make an application, obviously, to the judge and the CFI to vary the bail conditions. Disaster. Defendant's case is about to be called. He's on bail, but nowhere to be seen. What do? Slide down your seat when the case is called. Defendant needs to face the music himself. It's not your fault. B, the court's wheels are turning. What can you do other than tell the court the truth? You've no idea where the defendant is. Or C, have the solicitor quickly call the defendant. Why is he not here? While you are waiting, approach the court clerk and use your charms to delay the case. As funny as it sounds, the correct answer is actually C. Remember, court clerk, most important person in the court. You can persuade them to move your case further down in the list. They're going to have lots of cases due to be called. If you can persuade the court clerk to move your case further down in the list for the day, then your client may be able to make it in time to the court without the magistrate even realizing that he's running late. So that's the best option. So they have their list for the day, right, of the order in which they're going to, if you go up to the court clerk and you say, would you mind putting my case further down the list? I see it's listed as number 2. Could you move it down to, say, number 15 or so, right? If you have a good relationship, they might agree. Yeah, they just call the other cases first, and you give your client extra time to make it to court. But you also need to take some instructions, right? Why is he late? Is it because the MTR is broken down? Is he in hospital? Is his dog just died? Like, what's the reason? So you can, if the case is called, then you have an explanation. Because if the case is called, he's not here, he's on bail, the magistrate could just issue a warrant for his arrest. So you want to avoid that situation. The court will refuse bail where prosecution objects on the basis of an ID parade. They have the right to investigate. There's an eyewitness who says he saw the defendant committing the crime. The witness is very respectable, a justice of the peace, where the magistrate suspects the defendant will abscond, commit an offense on bail, or interfere with a witness, or where there are substantial grounds for believing he would fail to surrender to custody, right? Not just the magistrate's suspicion, obviously. The test is substantial grounds for believing that he will fail to answer the bail, commit an offense, etc. How do you rate your chances of getting bail for your client? Epic failure, better to stick to corporate law. Average, not to worry, I'll just fake it until I make it. Okay, I still have lots to learn, but I feel I can do this with some practice and at least I won't embarrass myself in court. Or total confidence, it's going to be a walk in the park to infinity and beyond. Hopefully, just a funny one to end, right? Obviously, at your stage, we're not expecting a bail application at the level of an experienced senior counsel, right? I'm pitching the assessment at a realistic level of what I think you can accomplish in the very limited time of 3 minutes, okay? Based on the level that you're at, all right? So I'm not expecting you, like my PCLL students, the level we assess them at is the level of a junior practitioner. That's our expectations for them. I'm not assessing you at that level, okay? Because you're not there yet, all right? So don't worry, it's 3 minutes. It's only worth 20%. You'll survive. Okay, so that's the end of substantive lectures. Are there any questions before we end? If not, I will see some of you for tutorials next week. I will see the rest of you for the advocacy feedback lecture towards the end of February, when I'll go through all of the feedback you got as a group. I'll demonstrate the 2 bail applications from the tutorials, and then we'll have a bit of a break, and then I'll see you again for the evidence revision lectures and the criminal procedure. Okay? All right. Enjoy, have fun with your bail application. It may be more fun once you've finished, but I think once you've done, you will be proud of yourself for getting through it at least. And it will give you the confidence that you can do it. All right, see you.